This is a lecture from OpenTuition. To benefit from the lecture, you should download the free lecture notes from opentuition.com.
Again, as with all the other previous lectures and subsequent lectures in contract law, I'm going to give you this warning that the pages that you see in the course notes are full of case names, and there's no need to remember case names. They're not important for your purposes. The principles behind the name, the principles established by those cases are important, but the names themselves are not. We're into privity of contract, and the basic principle is quite obvious, I think. Only a party to a contract may sue to enforce it. But there are exceptions. Now, look, if I were in contract with John, the F5 tutor, if I were in contract with John, and I break the contract, what right have you got to sue me when I broke the contract with John? The only person that can sue, the only person that has any rights to enforce that contract, or to try to enforce that contract, is John. It's up to John to take a legal action against me and make me present myself at court and defend my actions. You have no right. Why are you interfering? So that's the concept of privity of contract, that only the people who are a party to the contract have any legal rights to try to enforce that contract. But there are exceptions. The person entitled to benefit under third-party motor insurance. If I'm in contract with an insurer, as I was actually yesterday, I'm in contract with an insurer, and I have an accident, motor insurance, then the person that I damage doesn't sue me. They sue my insurer. But the insurance company says, hey, no, we're not in contract with the injured person. We're in contract with you, Mike. Only you can sue. No, obviously that has to be the exception. That an injured party, where I have caused the injury, is able to sue my insurer, or their insurer actually, will sue my insurer and claim the money that way. So that's the first exception to the concept of privity of contract, that the injured party may sue an insurance company under the third-party principles, or fully comprehensive principles. Person may sue to enforce a contract entered into by his agent. When we get to agency, you'll see that agents are people that represent their principal, the person that employs them as an agent, and they typically will have rights and responsibilities, but their basic duty is to find people that they can introduce into contract with their principal, their employer. And in fact, they themselves will enter into contract with the third party, and the third party can sue the principal. No point suing the agent, probably. Sue the principal, get the principal to comply and accord with a contract entered into by their agent. A holder in due course. It used to be the case that bills of exchange were a part of the F4 syllabus, but they are no longer. Bills of exchange are no longer a part of the F4 syllabus, which is unfortunate, because it would give people like, sad people like me, the opportunity to define what is a bill of exchange. And the definition was in the 1892 Bills of Exchange Act, and it said a bill of exchange is an unconditional order in writing addressed by one person to another, signed by the person giving it, requiring the person to whom it is addressed to pay on demand or at a fixed or determinable future time a sum certain in money to or to the order of a specified person or to bearer. Now, that's what a bill of exchange was defined as in the 1892 Act, but it's no longer part of your syllabus, so there's no need for you to remember any of that, but that's what it was. What is important is that according to the Checks Act of 1957, and you don't need to remember that, you don't need to remember Checks Act and the year 1957, but a check is a bill of exchange drawn on a banker, payable on demand. So the checkbooks that you may or may not use, you're probably fully into internet banking now, and I understand that checks are going to be taken out of out of use. But internet banking says that you can pay over the internet, so you don't need to write out these silly checks. But a check is a bill of exchange drawn on a banker, payable on demand. And a holder in due course. A holder in due course is a person that has taken this bill of exchange by process of negotiation and has given value in exchange. So a holder in due course can sue all prior signatories to that bill of exchange. Now, even though it's like me writing a check to you in your favour, payable in 3 months' time, or bill of exchange payable in 3 months' time, and you want the money now, so you go to a friend and say, will you pay me, if I write it to you for £1,000, and you say to your friend, will you give me £900 now, and you can collect £1,000 from Mike in 3 months' time? And they say, yes, all right, and so you sign it in their favour. But they then decide that they want some money quickly, so they sell it to a friend for £910, and they sign it in favour of the friend. And it can go round and round and round through all these people exchanging value and giving money in exchange for this bill of exchange. And then comes the time 3 months on, and they are the holder of a bill of exchange, and they present it to me, and I'm saying, I'm sorry, I have no money. I have nothing. So what they can do is they can sue you and all these other people that have signed their name on the back of the bill and signed it on. They can sue all of those people. So a holder in due course is able to sue any and all of the prior parties to that bill of exchange. Now that destroys privity of contract, because the person who presented it to me and I dishonoured it has no idea who you are, nor your friend, nor his friend, nor his. All they know is the one that has passed it on to them. And the only person that they know is the one that's passed it on to them. So we go backwards like that until eventually it comes to you. And you sue me because I owe you £1,000. Where a special relationship exists, for example, the executor of a will or the administrator of an estate can sue to enforce a contract that was entered into by the deceased. It is as though they have assumed the position of the deceased person. So an executor of a will can sue to enforce a contract that the deceased person entered into before their death. And that was the case. It was groundbreaking stuff, this. Groundbreaking, almost within my lifetime, almost. And it's a case Beswick and Beswick, and it was about an auntie and a nephew. This one is the auntie. The first one is the auntie. And her husband, now deceased, had entered into a contract with the nephew. And the contract said, I will transfer to you my coal merchant's business if you will pay to me £6 per week, and after my death, you will pay £5 a week to your auntie, to my widow. And the nephew agreed. And he died, the old man died. And he had been paying £6 a week to his uncle, and he paid £5 to his auntie, and then he said, no more, auntie, I'm sorry. And she said, but you entered into a contract with your uncle. And he said, I know, but get him to sue me. Let him sue me, knowing that he's dead. So instead, she got the executor of the will to take action on the deceased husband's behalf. It wasn't the auntie suing, it was the executor suing on behalf of the deceased husband. And Lord Denning, who was the master of the rolls, the head honcho in the Court of Appeal, said, yeah, I'm going to allow, in appeal, I'm going to allow the legal representative of the deceased person to sue to enforce a contract entered into by the deceased person. And so I'm going to create an exception to the concept of privity of contract. And the nephew, of course, defended it. Lord Denning said, no, I'm going to do this, but I'm going to suggest that you appeal to the Supreme Court, the House of Lords, as it was then. Make him appeal to the Supreme Court. Now then, what are these 5 law lords, these 5 judges in the Supreme Court going to do? They can either turn over Denning's decision They can either overrule, reject, reverse. They can reverse Denning's decision on the basis that that goes against the concept of privity, but it would also go against natural justice. Or they can go along with Denning and create this exception to privity. So, in his cunning way, Denning had seen to it by creating this apparently wrong, groundbreaking, innovative decision, he had seen to it that the law lords had to accept in the Supreme Court, they had to accept that Denning's decision was in pursuit of natural justice. Brilliant. Denning was wonderful, really good. A beneficiary can sue a trustee. Trust law used to be part of the syllabus. It's not now. So I'm going to leave it at that. The beneficiary can sue a trustee. If I, very, very quickly illustrating, if I were to put this pen for your benefit, I'm going to put this pen into the hands of my wife because I think you're too young to look after the pen and get the full benefits of it. You'd probably go and sell it and squander the money on pleasurable activities. So I'm going to give it to my wife until you were 25, and then she will transfer it to you. Now I'm the testator, I'm the donor. My wife is the trustee, and you are the beneficiary. And she's holding this on your behalf. And now I die. When you're 25, you say to my wife, my widow, 25, can I have my pen now that Mike gave to you to look after for me? And she said, well, I'm not in a contract with you. You're in a contract with Mike. Sue Mike. No, because Mike's dead. Doesn't have to be, actually. I could do this in a lifetime. So if I'm dead, you can't sue me. So exception to privity says you can sue the trustee who's holding trust property on your behalf, on behalf of you, the beneficiary. And that is now, obviously, an exception to the concept of privity. I recommend you read this case, this next one. It's almost Alfred Hitchcockian, Stephen Kingish, this one. Manufacturer of goods may be sued by the ultimate consumer. Every now and then you read in newspaper, when there's not much news around and Donald Trump is not threatening nuclear war or being misogynistic, when there's no news, the tabloids will dig up a story. And the story often involves things found in food products, like a dead sparrow in a sliced loaf. So you eat the crust and then you eat a bit of darkness in that next slice, and then you open it up and there's a dead sparrow been sliced up. It had flown into the bakery, got mixed up in the dough, baked, wrapped up, sliced and then wrapped up, and there you got this dead sparrow. And of course the manufacturer's in deep trouble because they should take extra care to keep birds out of their premises. Manufacturers have to take care, bearing in mind the ultimate consumer. They don't know who the ultimate consumer is. How can they know? Donoghue and Stevenson established, I think it was 1936. I'm simply saying that it's about 80 years ago. I'm simply telling you how long ago this was the case, but don't need to remember it. No need to remember Donoghue and Stevenson, but you may. You may do when you read it. It's about the decomposed remains of a snail found in a bottle of ginger beer. But it wasn't found until the boyfriend had poured half the ginger beer into the girlfriend's glass and she'd drunk it. And then he poured the other half in, but it didn't pour smoothly. And then and a black lump fell out of the bottom of this, fell out with the remains of the ginger beer. And these two looked at it. And she said, what's that? He said, "It looks like the decomposed remains of a snail." And she said, and was sick all over, bringing up anything previously that she'd drunk from that bottle. Now the question is, who can she sue? She can't sue the boyfriend because she'd not given him any consideration in respect of him buying her a ginger beer. He can't sue the cafe owner because he was not the one that suffered any damage apart from the cost of cleaning his suit. He can't sue the manufacturer because he wasn't in contract with the manufacturer. The cafe owner was in contract with the manufacturer. She can't sue the cafe owner because she wasn't the one that bought the ginger beer. She can't sue the manufacturer because the manufacturer's in contract with the cafe owner. Who can sue whom? And the answer was breach of privity. Forget privity. The manufacturer owes a duty of care in tort, not in contract, in tort. So a separate element of English law F4. The manufacturer owes a duty in tort, not in contract. And the duty is to take care of their legal neighbours, to have their legal neighbours in mind when they manufacture their goods. And clearly allowing a snail to climb into a ginger beer bottle before its cap is put on and to decompose in all this sugary ginger beer, that was not taken sufficient. So it was allowed for the injured party, the girlfriend, to sue the manufacturer. Look it up. It's a fun case if you like if you like reading about decomposing snails in bottles of ginger beer. Donahue and Stevenson. An employer may be sued for the negligent acts of their employee. Well, yeah, because it's as though the employee is acting as an agent on behalf of the employer. And although, therefore, in this case, the crane driver himself was negligent, the person injured, there's no point suing a crane driver because the crane driver doesn't have public liability insurance. But the employer does. Mersey Docks and Harbour Board does have public liability insurance on behalf of the negligent. And so do you, probably. If you're employed, if you're in employment, your employer will have public liability insurance. And so will you if you're employed by an accountancy firm, because your accountancy firm will take out what's called professional indemnity insurance, which makes sure that any negligent acts by you, like shredding your client's files and working papers, Arthur Anderson from many years ago, any negligent act by you will be covered by the professional indemnity insurance that your employer has to have taken out. Restrictive covenants on land apply to subsequent owners. Talk on Moxhay about Leicester Square. That Leicester Square, previous owner of Leicester Square, had written into the ownership documents that Leicester Square should only ever be used as a pleasure place for Londoners. It was before it got built up. But that's why Leicester Square, buildings surrounding Leicester Square, that's why they're theatres and cinemas and bucket shops selling tickets to these theatres. It's a pleasure area. I'll not go any further into what sort of pleasures may otherwise be enjoyed, but Leicester Square can only be used for pleasure purposes. And in collateral contracts, Shanklin Peer and Detail Products. Shanklin Peer had been recommended by their painter. Shanklin Peer wanted to have their pier repainted. So they contacted a painter, and he said, I recommend that you use Detail Products, detail paints, because that should withstand all the elements involved in having a pier by the seaside and all the salt and the erosion and corrosion and so on. So they did, and the paint was useless, it was no good. So Shanklin Peer, having acted on the advice of this painter who had recommended, what's the point of suing the painter? No, you might as well sue the manufacturer. So Shanklin Peer were allowed to sue the manufacturer, even the Detail Products, even though the contract for the painting was between Shanklin Peer and the painter, and the paint itself had been bought by the painter from Detail Products. Painter has lost nothing, so he can't sue Detail. Shanklin weren't in contract with Detail, they were in contract with the painter. Who can sue who? And the exception to privity, in a collateral contract, we entered into it because we were recommended by our painter to enter into that contract. Pinnell's case, something like 17th century case. It's a tremendously old case, 400 years old or so. Part payment of a debt does not achieve full settlement. Where you owe money and you pay some of it, that doesn't discharge you of the debt from the debt. The remainder is still due, but there are exceptions. It's illustrated by a case called Folks and Beer, but again, nothing you don't need. So receiving something different in kind, to which you are not entitled. So if I owe you money and I give you a car instead, and you accept it instead, then that's the debt discharged, even though the car may be worth less than the amount that I owe you. So receiving something different in exchange, and you accept the receipt of this something different in exchange, that discharges the debt. If I give you goods instead of cash, the same principle. If I give you services in exchange for the debt, same principle. Settlement before the due date. If I owe you money in 3 months, 1,000, and I offer to pay you in 2 weeks a lesser sum, and you agree, then that gets good discharge. I don't owe you the rest. So settlement before the due date gets good discharge. An arrangement with creditors that they will accept part payment in a liquidation situation. The liquidator will write to all the known creditors of the company that he's liquidating, and he'll get 75% consent, 75% by value, 75% by number, and he'll say, if you will accept a payment of 3 pence in the pound, for every pound that I owe you, that the company owes you, if you'll accept 3 pence, 30 pence, whatever, and they 75% by number, 75% by value agree, and then that gets good discharge of the debt. The rest is cleared, written off. Payment by somebody other than the debtor. So if I owe you money and John Moffat, F5 lecturer, pays you and said that's in place of Mike paying you, pays you a lesser sum, it says there, that's in place of Mike's debt, he no longer owes you. When you accept that, then that's it, debt discharged. If you don't accept it, you send it back and say, no, I want Mike to pay me the full amount. Payment at a different location. We've agreed that I shall pay money into your NatWest bank account in Bury, in Lancashire. And you say, no, you don't want it paid there. You want it paid into the NatWest bank account in the Channel Islands for whatever reason. So I pay it to your account in the Channel Islands. We had agreed that it would be paid in Bury. Now you've changed your mind and said you want it paid in the Channel Islands. Okay, but I'm going to pay you a lesser sum than was originally owed. That gets me good discharge because you've changed the terms of where you wanted payment to be made and where I had agreed for it to be made. There is a doctrine of promissory estoppel, where a promise is given and received and acted upon. The promisor cannot subsequently go back on that promise to the detriment of the promisee. And there's a case called Central London Property Trust and High Trees House. There are other cases, Coombe & Coombe, D&C Builders and Rees. I'm not going to go through those, but I want to tell you about Central London Property Trust. This is a case in the early 1940s. And although you needn't remember the date nor remember the name, the date actually is important. It's crucial to the case because in the early 1940s, England and Wales and others were at war with Germany. The Central London Property Trust and High Trees House. Central London Property Trust were the owners of High Trees House, a building in London. And the High Trees House owned or rented the High Trees House. The High Trees House company rented the property and leased it to tenants. But of course, who wants to live in a multi-storey block of flats in London in the middle of a war? So they found it very difficult to find enough tenants to pay them money to pay the rent to Central London. So they approached Central London and said, we can't pay this much, it's too much, we can't get the tenants, what can we do? So Central London Property Trust said this: instead of paying us £2,500 each year, for 1941 onwards, just pay us 1,250. If you pay us 1,250, that's okay. So they did. They managed to get half tenancy, so they were able to pay 1,250. 1941, 42, 43, 44. And then the war ended. So for 4 years, they paid half rent. And then Central London Property Trust said, 4 times 2,500 is 10,000, less 4 times the 1,250 that you've already paid us. So now you owe us 5,000. Can we have our money, please? You promised us in 1941. You said if we pay you 1,250, that would be all right. That was it. Yeah, but circumstances have now changed, and so now you can get full tenancy. So now you can pay us the back rent that you owe us. And it went to court. Central London Property Trust sued and said, we want our money. And the court said, oh, where a promise is given and received and acted upon by the promisee, then the promisor cannot go back on that promise to the detriment of the promisee. Now circumstances have changed, 1945 onwards, now you can go back to 2,500. You can't go back on your promise for these previous 4 years. And that's the doctrine of promissory estoppel, where a promise is given and received and acted upon by the promisee. The promisor cannot go back on that promise to the detriment of the promisee. The next topic, in contract. Remember, a contract is an agreement supported by consideration made with intention to create legal relations. Well, the next topic is intention to create legal relations. And I'm going to make that the subject of a separate